Our next speaker is Professor Bruce Arnold from the University of Canberra. He is a professor of intellectual property law and technology. And it's a pleasure to have him, and we are thankful to him for gracing this event with his physical presence. And his research considers the human rights implications and regulatory issues of disruptive technologies like 3D printing and robotics. In his today's talk, that is entitled Bioprinting, the Internet of Bodies and Human Rights, he will be discussing the patent challenges and regulation of bioprinting from the perspective of the right to health. I hand over to Professor Bruce.
Thanks. And I'll just put a short disclaimer. I'm an assistant professor, particularly feeling humble after that presentation, rather than a full professor. Though, of course, if you want to promote me, just show me the money. Okay, so yes, as Matthew may have warned you, I'm sort of notoriously irreverent. So law was famously characterised as marching with medicine, but in the rear and limping a little. And in this presentation, I'm going to suggest that some technology, in the form of bioprinting, a making if you like, a making that's otherwise known as biofabrication, is sprinting ahead of medical practice and therefore of law. I'm going to suggest that we can evaluate intellectual property and accordingly seek to restructure law through human rights, specifically the right to health. And I'm also going to touch on the Internet of Bodies, otherwise known as the IOB, where making in hospitals and other health precincts may well serve universal goods. Now, my contention is that we can construe human rights as a matter of fairness and flourishing. And through that lens, the health professions, and indeed the state, will respect, or should respect, the dignity of every individual and facilitate their flourishing by ensuring access to health services, including surgery, medical devices, and rehabilitation. And we've heard references this morning to rehabilitation and to devices. COVID-19 is a reminder that the same lens can, and indeed should, be used for understanding patents and other intellectual property, legal contracts whose existence is justified by community goods rather than the enrichment of rentiers such as the Sacklers, our oxycodone people in the US, and Martin Shkreli, the farmer kid, or through the trade-offs in geopolitics that we see in Australia and elsewhere. You look after our defence, we'll give you various intellectual property concessions, as we've heard a number of times, including from Matthew and some fairly hard-hitting submissions to parliamentary committees. Australian consumers end up with a worse intellectual property regime than their peers in the US. That's called geopolitics. So discourse about human rights includes reference to a right to health, something that on occasion seems rather mysterious. It's something that's under-theorised and in practice is limping a long, long way behind justice. It's traditionally been understood as a negative right, a prohibition on the arbitrary discrimination such as exclusion of particular cohorts from access to health services and prohibition of practices such as sterilisation of minorities on the basis of poverty, ethnicity, or political affiliation. The right to health can, however, be understood as a positive right. In other words, an expectation that states will actively reshape markets to ensure flourishing by ensuring everyone has timely access to high-quality health services irrespective of wealth or location. And location is relevant in places such as Queensland, where not everyone lives in beautiful Brisbane. Now, more broadly, the right to health includes an expectation that states will actively foster collaborative and individual well-being through restrictions on tobacco advertising, so no more trademarks uber alles, and through active use of TRIPS flexibilities alongside mechanisms such as sugar, alcohol, and even fat taxes. Now, such a right to health means not leaving flourishing to markets that are inherently unfair and that results in an inequitable rationing. So how does this relate to patents and printing? The promo for this presentation referred to the IOB, Internet of Bodies, and bioprinting, two discrete areas of innovation that involve intellectual property and involve other areas of law. I suspect most of today's audience, most of us, have a sense of the so-called Internet of Things, devices large and small that have some sentience and have some connection with the internet and that necessarily often embody IP rights. Cars, for example, are now computers on wheels. They're complex and they're smart, and as we're seeing in the current Australian debate about the right to repair, and this month's Treasury consultation about the Motor Vehicle Service and Repair Information Sharing Bill, which is even more complicated sounding than the name of the legislation, they're no longer the sort of device that's readily fixed at home with an authorised part or a part that's been made by a maker. And as technology sprints ahead with machines running close behind, with medicine running close behind, we're starting to see the Internet of Bodies. William Gibson famously quipped, "The future is already here. Just unfortunately for some of us, it's just unevenly distributed." So microchipped cats, dogs, cows, and even people such as biohacker Ludo, Disco, Gamma, Meow, Meow are all parts of the Internet of Bodies. The Internet of Bodies is more than such identifiers. It includes smart devices that aid health. It might be wearables. And at least some of you, looking remotely today or in person here, some of you are using a Fitbit. A Fitbit that provides data that will soon be mined by Google and its partners in an instance where competition law and privacy law hasn't caught up with the technology. More saliently, these devices might be implanted devices such as pacemakers and pain pumps, devices that are now sufficiently smart, sufficiently connected to communicate with databases and other devices on an episodic or ongoing basis. Such devices are wrapped up, of course, in patents, they're wrapped up in trademarks, and a soft form of regulation, they're often wrapped up in standards. They won't be made, and I very much hope won't be implanted, in a biohacker's kitchen or garage. What we might, however, see instead is assembly in a handful of Australian hospitals using authorised components that are still under patent protection and that communicate using open source or proprietary protocols. One key challenge for bodies such as Australia's Therapeutic Goods Administration, our counterpart of the FDA in the United States, is to actively encourage public goods through global open source rather than reinforcing monopolies. State and private investors have scope to do so, given that they're the primary funders and indeed make rules about implementation. Now, from a law and economics perspective, rather than merely a human rights perspective, the opening up of proprietary silos makes sense for the taxpayer and for national productivity. However, it requires imagination. I'll come back to imagination at the end. It requires imagination and smarts in international trade negotiation, both of which sadly seem to be lacking in Canberra and have been for some time. It also requires better funding and culture change at the TGA, a body that regrettably is a manifestation of regulatory capture. Now, much wellness doesn't require smartness and doesn't require connectivity. We can therefore expect uptake of 3D printing in hospitals and other health service venues for fairly low-tech devices that contribute to quality of life. And we had our reference this morning to both quality of life and to low-tech. Low-tech devices that contribute to quality of life are not high-tech and are not in themselves necessarily patent protected. And by that I mean printing of customised splints, casts, orthotics, and even dentures. Dentures can make a huge difference to quality of life, particularly if you're poor and you can't afford them. Printing of these things, these devices, in locations where there is sufficient demand to justify investment by public and private health service providers in purchase of printer hardware and training of the people, not necessarily amateurs, not necessarily enthusiasts, sometimes professionals, the people who will operate those printers. Now, I mentioned before biofabrication. From a research perspective, that printing is almost as exciting as the discovery of antibiotics. That's a fairly strong statement. Unfortunately, unlike the COVID-19 vaccination, we won't see much of this biofabrication, bioprinting widespread in the near future. And ironically, I suppose this goes to the heart of my presentation today, ironically that means there is still scope for developing a fairer regime by reorienting intellectual property frameworks. So, what's biofab? Most of us have encountered references in the mass media, sometimes specialist media, to a kinder, gentler, and possibly even safer way to produce meat. Meat that's grown in a lab vessel, generally not in a test tube, grown in a lab vessel, and ultimately might well be grown in a machine on an industrial scale rather than in a cow, pig, chicken, or duck, or deer, whatever you want to eat. It's a reflection that we're starting to get enough understanding of cellular processes to produce food in ways that don't involve Peter's characterization of farming as gruesome death to innocent animals. And Peter, I think, would say that all animals are innocent. The humans are the ones who are guilty. Now, bioprinting is a radical extension of traditional maker technology. The vision is that biofabrication, bioprinting devices, very sophisticated, very expensive, and currently very blue sky, will be used to generate skin, organs, and bone for placement in recipients of healthcare. Revolutionary. And it's important to note that this bioprinting involves organic material, not substitutes. So you might, for example, I'm only going to give you one example, you might, for example, receive a bone that's derived from a sample of your own cells, or a replacement, ideally a replacement kidney or a liver on the same basis, rather than something made from titanium, carbon fiber, and other material that features in class actions about defective joint implants. We're watching the J&J class action with joint implants at the moment. Now, this vision is immensely exciting and attractive. It offsets a range of problems. Problems, for example, with compatibility, problems with the adverse effect of drugs used to deal with transplant rejection. And at a more prosaic level, it offsets the unwillingness of many Australians to engage in organ donation and the difficulties that we have with donor matching. Bioprinting, however, raises new challenges. Fans of the singularity will presumably enthuse about the potential for indefinite life extension. Mark Latham and Craig Kelly will need to be reassured that existing law will continue to protect you. It will prevent you from bioprinting a clone of your children, irrespective of whether the technology ever advances to something like Westworld. And self-described Australian biohackers such as Mr. Meow Meow will presumably get media attention for a citizen science in which they move from a do-it-yourself genetic recombination to playing with bioprinting an organ or two or even some skin. And in a bleak moment the other night, I worried that the latter, bioprinting of skin, might well be in vogue for people with bad ink, bad tattoos. I've always been too scared to get one, I confess. People who might want to outdo Wim Delvoye, the famous artist who's mocked the cult of trademarks by tattooing those marks onto live Chinese pigs. So, would anyone want to buy a metre or two of skin inked with the artwork of your choice? Enfant terribles will presumably attract regulation outside intellectual property and outside the Gene Technology Act 2000. My suggestion is that in thinking about making the Internet of Bodies and bioprinting, we do, however, need to think about intellectual property and a range of other law. The IOB is attracting popular attention regarding liability and security, with, for example, a recurrent headline about death by pacemaker. And as with Fitbit, there are questions about privacy frameworks and questions about the capability of regulators. My suggestion today is that in thinking about the shape of intellectual property law and practice, when considering flourishing and fairness, we need to look beyond those concerns. This technology is more than just a matter of security, it's more than privacy. Intellectual property law regarding making provides an opportunity to critique that law, to critique IP. in order to deepen the right to health. Now, I've highlighted the blue sky status of bioprinting because we should not act as if we're locked into particular outcomes, into a particular future. We do have a choice. This is the great thing about law. Not necessarily about gravity, not necessarily about light. With law, you do have a choice. You can change. So my suggestion is that governments, research institutions, and foundations should expressly commit to open access regarding the patenting of bioprinting. And that's a reflection of the reality that much of the science underlying bioprinting derives from publicly funded research. It's not truly original. Recall the work by Matthew Rimmer and by colleague Wendy Benithan, Wendy's at Bond, regarding the basis of Myriad's patents in discovery outside that corporation. Ultimately, Myriad is stepping on the shoulders, or sitting on the shoulders, sitting comfortably and profitably on the shoulders of giants whose work was funded by the state. Open access requires some bravery on the part of universities. It will, however, serve to foster flourishing. It should please both the Productivity Commission, those rather dour economists in Canberra, and the economists who look after Australia's medical benefit schemes. Now, as a legal scholar, I'm reluctant to refer to fundamental human rights, but the right to health should in practice be regarded as fundamental, given that the absence of health, and indeed the absence of life, determines an individual's exercise of the various other rights that we more traditionally refer to as human rights. And I can well imagine a gasp of horror coming from Health Minister Greg Hunt or TGA Executive John Skerritt, and even the people at the ARC or NHMRC, where there's very much a focus on money and patents. So I'm going to offer a more modest suggestion based on what we're seeing in dealings by governments with providers of vaccines. Those dealings are shrouded in secrecy, something that represents a big pharma business as usual approach. The sort of thing that we've seen in Europe in the last week or so. If we are going to privilege intellectual property owners regarding biofabrication processes and biofabrication material, we should require transparency. In essence, if you want to make money in the health space, you need to be open about prices, costs, and conditions. Transparency and intergovernment cooperation, the sort of thing that we're starting to see with COVID-19, transparency and intergovernment cooperation should inhibit traditional practice that involves differential pricing across markets in the global north and that often excludes people in the global south. So we can think of a right to know as a foundation of the right to health. And finally, at the national and international levels, we should be looking at the interaction of standards, trade secrets, and regulators such as the TGA and FDA. Having spoken rather sort of pessimistically on health and the FDA and Donald Trump a couple of years ago, I think it might have been in the room over there, I'm actually hopeful that the Biden administration will rebuild the progressively weakened FDA. In Australia, we need to do something. We need some cultural change within the TGA alongside substantially greater resourcing for that agency. That might well serve to emphasise efficacy as a criterion for the approval of medical devices, including IOB implantables, and the large-scale kit used for biofabrication. It would address misuse of standards as innovation barriers, barriers that protect a handful of dominant and offshore biofab groups. And we might recall Matthew Rimmer's data on what appears to be a Pareto or a long-tail distribution of patents regarding making. The big ones, arguably most of the important ones, very much clustered among a handful of rights holders. This is akin to what we see with high-tech equipment in the pathology sector and what we're starting to see with robotics. Looking at barriers, going open might well encourage health service providers to choose open source printing solutions. A brave national government might even actively build biofabrication clusters, makerspaces that would bring together researchers, and health service providers. And that initiative would be underpinned by the forgotten people. And I'm not talking about Robert Menzies voters. The forgotten people, in other words, are the machine builders and other artisans who have recently been lost from several universities and whose training is not valorised through underfunding of the TAFE system. Now, to wrap up, a Russian practitioner of regime change, overall a fairly loathsome man, once damned Tsar Nicholas II as a man who was passive, unimaginative, and unable to ask the right questions. A stupid man rather than a bad man. An unimaginative man rather than an evil man. In thinking about making and health, I want to conclude by suggesting that we need to question the IP givens and act so that we do have choices. We need to act. Now is the time for informed Australian and international debate about bioprinting and about IP as a basis for public health, ahead of IP as the darling of private equity.